The next bill is SB 254, Senator Harold Jones.
Got some handouts.
The packet to show up here.
Yeah.
Senator Jones, do you need one?
Anytime you're ready.
All right. Thank you, Mr. Chairman. This is Senate Bill 254. It's just a little cleanup bill on marijuana's issue. But it is, as we recognize in Georgia, we're heading towards a criminal justice reform. We just passed a big bill today out of the Georgia Senate. We prosecute marijuana in two ways. Number one, as a felony. Number two, as a misdemeanor. This particular bill would state that in Georgia, it would only be prosecuted as a misdemeanor. It would eliminate felony possession of marijuana. It would not eliminate the selling of marijuana. Why going through this? And there's a couple of reasons. Number one, when you talk about having a felony on your record, it prevents a person from serving on a grand jury. Persons are expelled from public education, also expelled from private schools. It prevents by law a person from sitting on a jury. It also can cause loss of professional license. Now, the criminal justice reform bill we just passed today eliminated the automatic bar to receiving a professional license, but a felony would still be a consideration that one could take as far as preventing a person from having a professional license. It is still a lifetime ban on TANF benefits. It also can cause loss of Hope Scholarship. And of course, when a person is convicted of a felony, the impact that it will have on any future employee. So based upon those tough consequences that come about from a felony, it was my idea to basically say we would eliminate felony possession of marijuana. And there's two questions that probably come up from that. Number one is, why not have a limit on it? And the normal question that comes up about not having a limit is, would it allow persons to travel with just an exorbitant amount of marijuana, and there's nothing we could do about it other than just prosecute them with a misdemeanor? And I want to address that aspect, but I also want to just look at other states. And Mr. Chairman, you kind of mentioned before, and I'll just go through it very quickly. There are approximately 25 other states that have a higher felony amount than Georgia does. And I've given you a list of all the different states, and that's for you to keep and go through your perusal. And I have a definition page that kind of goes through it. Two of those states that have higher felony amounts than Georgia are Texas and Utah. And as you look through this packet that I gave you, you'll see where it has maybe like RG and some letters behind it. That would mean something like Republican governor, Republican legislature. Texas and Utah both are run by Republicans total. And what you'll see in your chart would say total Republicans, meaning that they have a Republican governor and Republican legislature. Texas's statute actually is up to 4 ounces. Utah is up to 1 pound. And there are actually up to 20, so there's 25 states who actually have higher felony amounts than what Georgia does. There are 20 states that actually prosecute marijuana up to 1 ounce. And some of those amounts are actually higher, but at least up to 1 ounce.
I'm sorry, they prosecuted how?
Up to 1 ounce, they only prosecute it as an infraction. It's not even a criminal offense. It's an infraction. It's just a traffic ticket. It's not even a criminal offense. Now, Mr. Chairman, in saying that, those states may still prosecute marijuana as a misdemeanor or as a felony, but up to 1 ounce, the way they prosecute it, and some states actually may be higher than 1 ounce, is just as an infraction. It's not a criminal offense at all.
Do we have in the Georgia Code something comparable to infraction?
Which, no, sir, it's just a misdemeanor. What is allowed is...
For any offense?
Other than, I'm not sure we have anything in the Georgia Code. It's just an infraction. And most of our crimes are just misdemeanors or felonies.
Right.
So there are 20 states that treat up to 1 ounce as just an infraction. There are 3 states that treat possession of marijuana or felony marijuana in what I call a hybrid 1. And what that means is they actually do not prosecute possession of marijuana, what they look at is if you have over a certain amount, they consider that a presumption that you're selling it. So they don't really prosecute possession of marijuana. If you go over a certain amount, they just presume that that's selling. And so really they have possession and misdemeanor. They don't really prosecute felony possession. If you go over a certain amount, it's just presumed that you're selling the marijuana. And one of the states that I had an example was Kentucky, which is also a total Republican state. That's Republican government, Republican legislature. So what they do is, if you have it over a certain amount, and I have on page 4 what their amount is, but if you have it over a certain amount, it's not felony possession, it's just considered to be selling.
And that was how much?
And, let me see,
What amount?
8 ounces or more
8 ounces or more?
in Kentucky.
Considered intent to sell?
that's correct. 8 ounces or more is a primary facie selling marijuana. It's primary facie that you're
That
selling.
doesn't help your case much.
Well, it would eliminate, remember, Mr. Chairman, we're not eliminating selling marijuana. Selling marijuana can be any amount in Georgia, and that's one of the things that I'm going to talk about. So for Kentucky, misdemeanors up to 8 ounces. After that, it's not possession that they charge you with, they just charge you with presumption that you're selling it. But that actually is what I've heard from a lot of persons. Well, if you have over 4, 5, 6, 7, 8 ounces, you're probably selling it. So that doesn't really hurt, in my mind, doesn't really hurt the case because we're not decriminalizing, this isn't decriminalizing either, but we're not reducing selling marijuana. Selling marijuana is still a felony.
Isn't there a presumption in Georgia at 10 pounds?
10 pounds is trafficking is the presumption.
Okay.
Trafficking is the presumption. 10 pounds is trafficking.
And below that, isn't it something that a court can take into, or a jury can take into account as a factor?
That's very key. And I'll actually skip over and I'll actually go to, and this is why when we talk about having an amount for possession, and when a person's asking, they say, well, can't a person ride around in their car with any amount and all you can get them with is just misdemeanor possession? What you're asking is very key, and I've provided you cases in here. And one of the cases is Cotton versus State. And what that case stands for is that the defendant had 2.7 grams, only 2.7 grams, and he was charged with possession with intent and convicted with possession of intent. A possession of
How much
intent
is 2.7 grams translated into ounces?
I'm not sure, Mr. Chairman, but it's less than an ounce because
Tenth of
it's,
an ounce.
yeah,
Less.
Tenth of an ounce.
Yeah.
A tenth, less than a tenth of an ounce.
because an ounce is 28.5 grams or somewhere around there. This is a Georgia case. He had 2.7 and was charged with possession with intent. Because our intent statute does not put an amount on it. The way we prove intent in Georgia is we look at all the surrounding circumstances. We look to determine whether they have scales. We look to determine how the money is bagged up. In this particular situation, he had $60 on it, and that was considered to be a factor that he was actually selling marijuana. So 2.7, a tenth of an ounce, and $60, and didn't have any scales. But the key was, and this is the key in almost all cases, and it will be the key of anybody riding around with an exorbitant amount. In Georgia, we allow the deputy to testify as an expert. And he can testify and say in his expert opinion, the amount in question is not for personal use.
The deputy?
The deputy can. He can say based on his, and I've provided those cases for you, those are cases you have in your packet, and it's outlined pretty clearly. What happens is the deputy can take the stand, and he can be qualified as an expert.
From experience.
From experience. And he can say that based on his personal experience, that the amount in question is not for personal use. I provided you a case in here where the only evidence was the amount. No scales, no money, no particular bags. The only evidence, I think it was about 16, it's actually about 16 ounces. That was the only evidence, and the deputy testified in his experience that would not be for personal use, and the court upheld that conviction. And that happens in courts all over the state every day. That the deputy can take the stand and say, in my opinion, it's not for personal use. So when we say, well, a person can just ride around around with a pound or 2 pounds and they would only get charged with possession, misdemeanor possession. That's totally inaccurate. Because if a person is riding around with that much, a deputy doesn't need a scale, he doesn't need money, he doesn't need a particular baggage. He can take the stand and say in his expert opinion, he's been on the force 5 years, he's made so many cases, a pound of marijuana is not for personal use. And the jury can convict.
Speaking of experience, your background, for several years you were a solicitor.
I was the actual Solicitor General for 5 years. I was a prosecutor for 12, total of 12 years.
How does your experience inform you on this issue?
In what sense? In what sense?
I mean, what did you gather or learn from your experience?
Well, I think what I
impacts
gathered,
what you're trying to do in the bill.
what I gathered would be, now we didn't prosecute felonies, but now having worked on the criminal defense side for the last 4 years, one of the things I've gathered is it's very easy to actually get convictions for possession to sale. So I think that the selling aspect will remain. There's two things that actually, the selling aspect will remain, and I don't think that this bill would impact that at all based on case law. The second aspect I gathered was that many times persons who are not quote-unquote criminals as such can get caught up in these kind of situations and have these really tough consequences that hit them, even if they're only prosecuted with a misdemeanor. Even if they're only prosecuted with a misdemeanor. We do have diversion courts and things of that nature, but we certainly are not going to put everyone in a diversion court, otherwise there would be no reason to even arrest them. So that's going to be for a select group of persons. My experience has been that only a few people get put in these diversion courts. So the majority of people are still going to be going through the criminal justice system the ordinary way. And that is why I went to this particular route in saying that any amount would be a misdemeanor. There are actually 10 states, Mr. Chairman, that do prosecute misdemeanor only. And out of those 10, 5 of those states are actually Republican states. And that's all in your packet that you can also take a look at.
Let me ask you, did you give any thought to having gradations for second and third, fourth offense?
Yes, sir. And that is
Is that already in there?
that it's not in this particular bill. I have given it thought, and the only aspect of that is we've never really had that in Georgia at all. So we've always been a black and white felony or misdemeanor. But to address your point, there are a total of about 9 states that do that. That say, okay, the first one is any amount, and then the second one may be an ounce or more. So your first offense would be any amount, and that would be a misdemeanor. There's about 9 states that handle it this way. And then your second offense, if it's over an ounce, then it would be a felony. So the question becomes what number to use. That's what I have trouble wrestling with, because as you look at all these different states, and many of them Republican-dominated states, you find just various numbers. When I say that you have states that are over Georgia, Georgia's 28.5 grams. Some states may prosecute a felony at, 30 grams, which is just a little bit over an ounce. But then you may have some states that don't prosecute as a felony until you get to a pound. So, in fact, I believe Louisiana was a state that did prosecute until you get 60 pounds as far as a felony is concerned. So the question that I've been wrestling with, and certainly because this is hearing only, not one that I'm opposed to necessarily, is what is that number then? What becomes that particular number that we charge the person with felony possession? Because we have to realize, the reason why I went through how easy it is to really prosecute a person for possession with intent, because the deputy can take the stand and say, based on my opinion, it's more than personal use. When a prosecutor gets a case, when the officers in the sheriff's office gets the case, and they have made a determination, even though they can just take the stand and say, based on my experience, if they truly come to the conclusion that no matter what the amount is, that this is only for personal use. That's all it's for. So you have a prosecutor who's looked at it, you have a sheriff officer who's looked at it, and they both say, really all we see is that this is for personal use. What then becomes that magic amount to say, okay, you should be charged with a felony? That's what I keep wrestling with, because it won't be difficult. First of all, a drug dealer, that's what he does. I'm a lawyer, I have law books in my car. I'm also a state senator, I have statutes in my car. A drug dealer is a drug dealer. They're going to have scales. They're going to have things bagged in a particular way. They're going to have money. That's what they do. So that's why you look at all these indicators, and plus the deputy's testimony. A drug dealer isn't going to be just riding around and it's not going to be separated in bags with no money and go to his customer and say, well, you know there's this new law, so I don't separate my stuff anymore. You got some extra bags? Or you know there's a new law, I don't carry change on me anymore. Do you have some change? A drug dealer is a drug dealer. That's why these guys get caught. And that's why we have all these indicators that we look at and we can look at the prosecutor. So that's why I say when a prosecutor, who make no mistake, I used to be a prosecutor, his intent is probably, if it's a lot of marijuana, and I'm not, obviously if it's over 10 pounds, we know it's trafficking, it's no big deal. But if we're talking about 2 or 3 ounces, his initial intent is to say that this guy is selling it. The sheriff's deputy initial intent is to say that this guy is selling it. But after they looked at this case, and they say to themselves, and even to a grand jury when they get an indictment, all we think this guy had this for. We know we can prove, we know we can put you on the stand and all of these kind of things, but as we've looked at this, the only conclusion we can come to is that he really just has this for personal use. What then is the magic number to say you should be charged with a felony? 4 ounces should be charged with a felony, but 4.5 should not, and that's what I've been wrestling with throughout this project.
All right. One thing that might be helpful, I appreciate all the information you provide us about what the status of other states around the country is. One other thing that might be helpful is to have some information about the volume of prosecutions, if there's any information that breaks it down by amounts and case numbers.
Yes.
All right. I thought we had a question.
Just one question, Mr. Chairman.
Yes.
Senator, thank you.
Yes.
Is there any difference in selling and trafficking? Use both of those terms. Are those one and the same?
It's really one and the same. It's just we say 10 pounds is trafficking and you get more time. And I think it's also mandatory that you're actually going to receive a certain amount of time. So trafficking and selling, trafficking just says it's over 10 pounds is trafficking. The key thing is what you get, your sentence. I believe selling is 1 to 10, but I believe trafficking is 5 to 20, and I think the 5 is actually mandatory.
Are they defined? I mean,
the time? Yes.
Defined?
Yes, the time is actually defined. The trafficking statute is 16-13-31, and it is 5 years minimum. 16-13-31.
Okay.
Yes.
All right. Any other questions from the committee? If not, we have a few people signed up. Sharon,
Ravert.
how do you,
Ravert.
Ravert. Okay, come on up. You can keep your seat, Senator. You might need to ask you questions. Good afternoon.
Good afternoon. Thank you so much for having this committee and opening up a conversation about this. I want to state first that you don't have to be pro-marijuana to be anti-prohibition and anti-arresting people for felonies. My name is Sharon Ravert. I'm 51 years old. I was born in Atlanta, lived here my whole life. I'm a small business owner, a wife, and mother of 2 college-educated and graduates, daughters. I am also the executive director of NORML. If someone had told me that I'd be speaking in front of you guys today 10 years ago about marijuana, I would have never believed it. I would have probably laughed at them. But that was before our local sheriff's department and the drug task force came into our home at 4 a.m. and pulled my daughter out of bed with guns pointed at her. They searched our entire home for hours and took her away in handcuffs for what amounted to 1.5 grams of marijuana, a joint, on her nightstand. That night changed everything. Little did we know it was only the beginning. It was obvious that she was in trouble as they let her out the front door and put her in the police car, but I would have never guessed how much. I was in shock 2 days later when they told me that she was going to be charged with 2 felonies and a misdemeanor. They wanted to put my otherwise law-abiding daughter in prison for 26 years. She was in a fight for her future, and that was made quite clear at the beginning. She was in the system now, and it was time for a bondsman, a lawyer, courts, lots of stress, worry, tears, and tons of money. Over the next couple of years, we were not shy about talking to anyone that would listen about that night and about what she was facing. People got sick of hearing it, quite frankly, but we didn't stop. We found overwhelming support throughout my small community of Dahlonega, Georgia, at every turn. Young and old, conservative and liberal. I'm a conservative, by the way, registered Republican. Rich and poor. I realized that I was far from alone in the thought that the punishment for marijuana was way out of whack. Prohibition was affecting our entire community. It was putting public safety at risk. People were losing respect for our laws and those that enforced them because of it. And this worried me greatly because I had several family members in law enforcement. I knew we had to find a solution to protect them as well. Eventually, people began opening up and searching us out to share their struggles and their testimony. I realized that shame and stigma kept people silent. I also realized how lucky my family actually was. Not everyone can bond out of jail. Not everyone can afford that lawyer. Not everyone has the support of their family, and not everyone gets a good plea deal on the day that we go to pick a jury. See, my daughter wanted to take it to a jury trial. So much can go wrong during drug raids as well. A few months later, after this happened to us, I heard on the news about a SWAT raid that went very wrong in Atlanta when Catherine Johnston, an 84-year-old grandmother, was shot to death on a botched drug raid. We are so thankful no shots that night were fired and that no one was hurt, including the police officers. We do own guns. We live in the country. We're not used to having people invade our house in the middle of the night, but we had had that happen to us recently, within a few months before that, and I'm very thankful that my guns were put in my gun case that night, because I would not have known they were officers. We are so, it almost took 3 years and her entire college savings to get a resolution on the case. She suffers from horrible PTSD. She wakes up at night screaming. I will tell you that 3 years ago, I got a call one morning and she was crying. I asked her what was wrong. She said, "Mama, last night was the first night that I've slept through the night since they came in on us. It broke my heart." My daughter's no longer a victim. She graduated with honors from the University of that's my other daughter, North Georgia, from the University of Georgia with a landscape architecture degree. Thank goodness she can get a license to practice. She's no longer a victim, as I said. She is also a loud voice of reason speaking across Georgia and the country about the harms of prohibition and the harms of treating people with felonies. She was told at that time, if you don't like the laws, change the laws. That's been her mission ever since. That is mine as well. We cannot change the past, but we can change the future for others. Yesterday I was watching at home in Dahlonega when Representative Golick was on the floor, and he reminded me of something that our Governor Deal said when he was talking about criminal justice reform. He said, quote, "We need to figure out who we're afraid of and who we're just mad at." I couldn't agree more. 1 in 3 of our children will be arrested for a nonviolent drug offense before they turn 23 now. A large majority will be for marijuana possession. We must stop the flow of our children being arrested and going to prison and going to jail and getting a record. And SB 254 is a good start. I'll leave you with one last thought. The evidence at this point is clear. The long-term health effects of incarceration are far worse than the long-term health effects of marijuana use. Thank you.
Thank you. Can you leave us your written statement?
I sure will.
And
If you have any questions, I'll be glad to answer.
I don't see any questions. Just if you don't mind, I do have one question. What was the, maybe I missed this, what was the ultimate disposition of your daughter's case, if I might ask?
She was facing 26 years, and what happened is we went in the day of jury trial. And when we had been to many court things, and they null processed both of the felonies, meaning that they dropped both felonies.
What were the felonies?
The felony was because she had separated the small amount of marijuana from the seeds and stems. I don't know if you realize it or not, but if you're caught in Georgia with a seed, it's a felony. One seed. No marijuana has to be present, one seed. And so the seeds constituted, I guess, the thought that one day she would put that seed in the ground and grow it. So she was charged with manufacturing marijuana and distribution.
Thank you. All right, next we have Marissa Dotson. Thank you.
Thank you so much, everybody. Thank you for coming to talk to us.
Good afternoon, members of the committee, and Chairman, thank you so much for having me. Again, my name is Marissa Dotson. I am the Southern, it's a long name, the Southern Policy and Advocacy Associate for the American Civil Liberties Union. I'm focusing on criminal justice reform in Georgia, Alabama, Mississippi, Louisiana, and Florida. And we're here today in support of this bill and of this idea that we start thinking a little differently about the way that we treat people who are in possession of marijuana. Given what the Senator said about how reclassification is happening around the country and the idea that people who are in possession of marijuana do not pose the kinds of public safety risks that we once thought that they did, this movement towards decriminalization in a way that says that people who are in possession of amounts for marijuana for personal use are not people we should be afraid of. This idea about even what a felony means and this classification of a felony. Historically, felonies were something that was seen as something very, very bad, right? Even in Old English, it was a felony, you could get the death penalty for the commission of a felony. And I think that thinking about people who are in possession of marijuana as egregious enough to label them as convicted felons and have them deal with some of the barriers that Senator Jones has already talked about around employment and licensing and their ability to civically engage. I also wanted to frame this discussion around how consistent it is with the efforts around criminal justice in Georgia for the last several years. And I've had the opportunity to be around and a part of significant reforms. Georgia is known as a leader when it comes to smart criminal justice in a way that saves taxpayer dollars and is thoughtful about the way individuals are treated in the system. And this movement around accountability courts, thinking about substance abuse in a meaningful way, and mental health issues and veterans issues. So if we're thinking about saving taxpayer dollars and saving prison beds for people who need to be there, then it would seem that people who are in possession of marijuana, when we know so much more about marijuana than we did when the statute was drafted, that we might think about a classification of the crime that fits the conduct and the behavior. And so for the sake of brevity and to not kind of restate what's already been said, I'll stop now and take questions if you have any.
Thank you. I don't see any questions. The next person is James Bell.
Thank you very much. Thank you for holding the hearing today and the courtesy to talk with you about some of these issues. My name is James Bell. I'm from Douglas County, Georgia, and I run the Georgia C.A.R.E project, Campaign for Access, Reform, and Education. And we advocate for cannabis law reform and represent hundreds of thousands of citizens of Georgia who consume cannabis. We estimate between 500,000 and 1 million citizens in Georgia consume cannabis regularly. Polls indicate 25 to 50% of the population has tried cannabis at some point in their lives. In Georgia, possession of more than an ounce of cannabis is a felony, with penalties up to 10 years in the state penitentiary. While it is true that few people actually receive 10-year sentences to serve, it is possible, and it has happened in this state. But there are many other consequences that we have to consider other than just prison. The stigma, the disabilities attached to a person who has a felony conviction carries out throughout their life. It affects their educational and job opportunities. Even with the pardon, the felony arrest will never be removed from the state database. Marijuana arrests in Georgia are grossly disproportional based on race. An African American is 4 to 10 times more likely to be arrested for marijuana than a white person. I'm not sure what those factors are, but that's a fact. We have some 30,000 arrests in Georgia each year for marijuana. Many of these are for more,
How many did you say?
generally 30 to 32,000 people are arrested in Georgia for marijuana. A lot of these are for felonies. And of course, you know, people with simple, small amounts. And if you will allow me, Mr. Chairman, I did bring a prop, and I wanted to demonstrate this, and I don't need a defense attorney today. This is tobacco. This is tobacco. I wanted to show you the difference between, one of these is a felony if it was marijuana, the other would be a misdemeanor. One is 27 grams, which I'll show you. This is 27 grams. This is 29 grams. This is over an ounce. This is 1 year in jail. This is 10 years in jail. I don't think we can really say there's a distinguishing between these two crimes. And this is why we're here today, because it's so disproportionate from, you know, we want to have disapproval of marijuana, but 10 years versus 1 year, this is what we're faced with in this state. Let me talk about a little bit about how people possess and how they go about this. An ounce of marijuana could cost $200 to $400, but 4 ounces may cost $400 to $1,000. So it's no different than buying any other commodity. You know, a 6-pack versus a case of beer. You know, you get a little cheaper buying it in a lot larger quantity. A lot of people do that. Some people try to avoid this week after week after week of purchase enough marijuana to last them 6 months or a year, quite frankly. I believe Senate Bill 254 is in line with Governor Deal's criminal justice reform measures we have seen over the past 4 years. The goal is to reduce the state prison population and the impact nonviolent offenses has on the criminal justice system and on the citizens. It allows the state to continue to punish those caught with cannabis, but this is not legalization, this is not decriminalization. It is harm reduction that will serve the ends of justice without destroying lives and the futures of so many Georgians. Cannabis law reform is sweeping this country. It has reached Georgia. It is time we look at reducing the harm marijuana laws have created for decades. We support this bill, and let's begin a dialogue and debate that can lead us to a more just, a less destructive criminal justice system. And I want to thank you for your time and for your consideration. I also want to point out that, shockingly, I just heard that there's a such thing as misdemeanor vehicular homicide. And I've never heard of that before, quite frankly. And I submit to you that marijuana does not reach any level of homicide. And if that can be a misdemeanor, I would say that the plus bag here certainly should not be a felony. And that's my testimony. I thank you very much. And I want to thank the Senator also for having the courage, the knowledge, and compassion to bring this bill up.
Does Senator Jones have your contact information?
Yes, he does. And I could leave you with a statement if you care. Thank you so much.
Statements. All right, the last person signing to speak is Roland Carlisle. Good afternoon.
Good afternoon. Thank you, Senator. Thank you guys for even considering the bill. My name is Roland Carlisle. I'm a resident of Atlanta. I live in Dunwoody, Georgia. And when I was in college, approximately 10 years ago, I'm 30 now, in Florida, I was convicted of possession of marijuana. I had just turned 20. I was virtually still a teenager. Once I was convicted, my life, well, actually, once I was charged, my life completely changed. I went from an honor roll student in the Honor Society every single semester to felony. Now, I did complete college, but it took me 6 years. And the reason that it took me 6 years is because of the collateral consequences that I faced once I was even charged. From that moment on, when I went to the internship office to speak to our internship office, if you had an open case, they told you don't even apply for any internships. As a result, I never received an internship during college. So when I was released from prison, I had to begin my career here in Atlanta, volunteering for a nonprofit for absolutely free, just to have something on my resume. Also, in addition to that, initially I wanted to be a financial advisor. I concentrated in finance and I was a business major. FINRA will not allow anyone with any felony whatsoever to obtain any licenses to sell securities. It doesn't matter what the felony is. It doesn't have to be any type of white-collar crime whatsoever. And so I had to, in order for me to become marketable, to become employed here, because I had no experience. Okay, I just had education. I had no work experience whatsoever. Even after that volunteer experience, I had to go into a program called WIA. It's a grant for people who have barriers to employment, specifically people like, who have felonies, and obtain some extra training, and that made me marketable enough, to be seen. And ultimately now, I'm a senior accountant with the largest accounting firm in the world, arguably. And so I wanted to say that.
What firm is that?
I'm Deloitte.
Oh, Deloitte.
And so, again, and the reason why I got hired by Deloitte is because Deloitte has fair hiring practices. They have banned the box. As you know, Nathan Dill has done here on state applications. And they gave me an opportunity to explain my the felony conviction instead of just barring me from employment. So if we didn't persecute individuals on a felony level for crimes such as possession of marijuana, we wouldn't have to have all these programs and spend all these millions of dollars, because not only do you have the WIA program and other programs like it, you have the work opportunity tax credit that the federal government gives a tax incentive to employers to hire people with criminal histories, and you also have a federal bonding program. So all of these programs are intended to reduce the collateral consequences of felonies. Now, we wouldn't have to have that if individuals who really didn't have any intent to commit any crime against society, they just simply possessed marijuana because that was their substance of choice. It's just a coincidence that that was the substance of choice. It could have been coffee, it could have been tobacco, or it could have been alcohol. All legal substances, which arguably has, just as negative side effects as marijuana, especially alcohol, as we know. And so, what disturbed me the most after this all is that individuals in other states, right, were charged with the same exact offense. However, for like the same amount, however, their crime is not a felony, and they get to maintain all of their constitutional rights. And so in Georgia, the great state of Georgia, I know that the great state of Georgia doesn't want to abridge the rights of its citizens in accordance with the 14th Amendment. If one state doesn't consider it a felony, why is there such a big disparity? Why are we 1 ounce, and why is New York up to a pound until it's a felony? So they get to vote, they get to serve on a jury, and I don't. In certain
You're not able to vote?
states. Here I am able to vote. In the state of Florida, I can't vote. But luckily here, you know, because you guys have great, here in Georgia, we have great criminal justice reform measures that were in place, so I can't vote here. But it's just an example of some of the collateral consequences.
What were you charged with?
It was actually possession of marijuana, and I think it was actually with intent, but it was possession of marijuana.
How much?
It was approximately 400 grams or so.
What's that?
Close to a pound almost, and not quite.
Okay. I don't see any questions. Thank you very much.
Thank you.
And that being all the persons signed up to speak, if there being no further business, meeting's adjourned.